But, I mean, maybe this, I don't know how this misleading idea even got into the case. This is just maybe sloppy work by the Seventh Circuit. But the instruction was you have to find that it's false. You could have argued and that, no, it has to be literally false, viewed by itself. You didn't argue that. In fact, my understanding is that the defense originally had asked for an instruction on literal falsity and then withdrew it. And then the jury found that the statement was false. And you're just saying no reasonable juror could view this as false in context? That's an awfully hard argument. So what's the point of remanding this to the Seventh Circuit? Just as kind of a punishment for having introduced this misleading idea into the case?
No, I definitely don't think the court would want to do that. But this is an important statute that deals with people's dealings with sophisticated financial entities. And it is important for the court to give some guidance on the question of whether a statement is misleading or false, precisely because the statute is so important and such broad application. As the court knows, in the Wells case, this court correctly found that there's no materiality element to the statute. So this statute could be used extremely broadly to punish a number of types of dealings between individuals and very sophisticated financial institutions.
Counsel, along those lines, in terms of whether a remand is worth it or not, I take it you don't dispute that you got a tough row to hoe with the standard, and no reasonable jury could have concluded. But here we have, as you say, an incredibly sophisticated questioner, the federal government no less. And the question, if it is a question at all, it's a statement. UO 269, he responds, I borrowed 110. The government itself says it understood him to be confused about how much he borrowed and how much he owed. And under those circumstances, we can make a judgment, or we could maybe leave it to somebody else to do it in the first instance. Them's our choices. Is that about it?
I think you've captured it, Justice Gorsuch. The
context here is not a couple of unsophisticated entities or individuals who've never had any financial dealings. But you have a tough road to hoe.
It's definitely a tough road to hoe whenever you're asking a district court to find that no rational jury could have found something. But there's a lot of evidence from which we can make a solid argument, an argument that I believe is correct.
But Mr. Geer,
could you spin that out, please, first?
Pardon me?
Could you spin that out?
Yes. Three data points. The first is that the government conceded below that the statements were literally true. The second is that, as I've said, in the call with the bank, the statement that was made was, I borrowed $110,000. I had a personal note for $110,000. Both true statements in the light of not a precise question or indeed even a question at all. And then the call with the FDIC was with these two FDIC examiners, and they made two comments that were very critical. The first is there was no question about how much he borrowed or how much he owed. Instead, they asked him about his personal note, and he said, they loaned me $110,000 on my personal note, which was true. And both of the examiners and the witness from the call center for the bank all testified that he didn't seem to know what it was he had borrowed. So I do think there's a good basis for the district court to make this decision in the first instance. And I think that this court should decide the important legal issue to make sure that prosecutors don't over-enforce this statute.
But what you just said...
Thank you, counsel. None of all this is pertinent on the home improvement loan statement, right?
Correct.
You agree that's completely false?
That is a false statement.
Okay, thank you. Justice Thomas? Justice Alito?
Well, your last comment is a fair one, but doesn't it go to a different question? It doesn't go to the question whether the statement was false in context. It goes to whether he knew that it was false. It's a mens rea question. It's not a question of the actus reus, which is the utterance of a false statement.
I agree with you that it goes to mens rea, but if we were to take the perspective of my friends to think that the perception of the listener mattered, that evidence would bear on this question. We don't agree that perception matters. In fact, the government does not cite a single case from this court suggesting that the question of truth or falsity depends on the perception of the listener. As a matter of fact, the very concept of misleading is from the perspective of the listener, an objective listener, and Congress knows how to make that relevant.
Well, I'm totally confused by your argument, because unless you're arguing literal falsity, then falsity in context does depend on how people would understand the statement. It does concern the perception of listeners.
I don't think so, Your Honor. I think that the falsity is an objective concept. If I say that the sun rises in the west, that's false, and it doesn't matter whether it misleads you or not.
It may not concern the perception of the particular person to whom the statement is directed, but it does concern the perception of some kind of listener. Otherwise, I don't understand the concept of falsity in context.
Well, if I make a statement and there's no listener at all, it is still capable of being true or false. And my point is that Congress over and over tells us when it wishes the perception of the listener to count by using a term that explicitly refers to the perception of the listener.